Stephanie Hewson is a staff lawyer at West Coast Environmental Law. She is part of the West Coast Marine Program. She graduated from McGill's Faculty of Law in 2016 and articled with the Ontario Ministry of Environment and Climate Change. She completed an exchange semester at UBC's Indigenous Community Legal Clinic in Vancouver and fell in love with the Wet Coast. I know it says West Coast on your bio, but I thought that really it's the Wet Coast here. She also worked for a summer for a Council of First Nations and Tribes in Yukon and Alaska to develop a government strategy for managing the Yukon River watershed. So I think Stephanie's going to be explaining a few things to us tonight about how some of the coastal and ocean protection laws and how that relates to our marine ecosystem. So Stephanie, so happy to have you with us. And go ahead, unmute yourself, I'll mute. And I would suggest if you have the ability to turn off your cameras, it should, except for Stephanie, of course, it should just help with a smoother presentation. Over to you.
Thank you so much, Joan. And I am equally honored to be here tonight and very happy to meet you all over Zoom. I'm going to share my screen so you can see, I guess, the occasion for this presentation. We just wrote and published a book called The Guide to Coastal and Ocean Protection Law in British Columbia. And when we decided to write this book, it was really people like you who we had in mind, people who love the ocean as much as we do and who want to know what tools are available to protect it. And we have been getting requests from different community organizations and other NGOs and Indigenous nations for legal analysis on how to protect the coast and ocean, so much so that we decided to write a book about it. And the book is over 300 pages long, so I won't go into every detail with you this evening, but one of the most important and most complex areas to understand with ocean law is the topic of jurisdiction, which is really who is in charge and who has the authority and the responsibility to do what. And it's the most important and first question to ask when thinking about derelict and abandoned vessels, restoring eelgrass beds, fisheries closures, anything that we can do to protect the coast and ocean. So I'm going to walk you through marine jurisdiction tonight, and we'll have some time for questions at the end. And if you have any questions as we go along, I think you can either keep them, I'm not sure how Q&A works here, but put them in the chat or we can talk about them at the end. So just a brief outline, I'm going to give you a little overview, broad spectrum of what marine jurisdiction looks like, and then talk about the different orders of government, Indigenous, federal and provincial, local government, and then finally tie it all together with an example of how these governments can and do work together to protect the coast and ocean. So first, we'll talk about international law. And international law is quite interesting because in some cases it sets the framework for how laws play out within different countries. The United Nations Convention on the Law of the Sea is a good example of that. And other times, international law is aspirational. It gives countries something to aspire to. And I don't know if you've heard about the federal government's commitment to protect 25% of the ocean by 2025 and 30% by 30, but that comes from international policy and guidance and the Convention on Biological Diversity. And one thing to keep in mind when thinking about international law is that though it is quite persuasive and can be very influential, it doesn't have legal teeth within Canada until it's been incorporated into domestic law. So for example, the UN Convention on the Law of the Sea has been incorporated, certain aspects of it, into Canadian law through the Oceans Act. And so that's how that law has force and effect here. You may have heard, I'm sure, about the United Nations Declaration on the Rights of Indigenous Peoples and how the BC government is implementing that within BC right now, and potentially the federal government will as well. So those are examples of how international law can influence what happens here. And this graph is a kind of an image of the different maritime zones and areas of marine jurisdiction that have been laid out within the UN Convention on the Law of the Sea. And this convention was negotiated and finalized in 1982. And before that, long before that, countries, coastal states, their jurisdiction stopped either at the shoreline or up to 3 nautical miles off the shore. And there's a few different stories about where that 3 nautical mile mark came from. Some people say it's as far as you could fire a cannon shot. Other people say it was the distance to which you could see a ship coming over the horizon. But generally speaking, there wasn't much of a concern about what happened beyond 2 nautical miles offshore. And that started to change as fishery stocks began to be depleted, and also as countries discovered mineral resources under their seabed. And so the UN Convention on the Law of the Sea was negotiated to define exactly what a coastal state like Canada's jurisdiction is over the ocean that's next to it. So in this graphic, you can see there's the mountain is sort of the height of land. And on the other side of that, we refer to internal waters, and those are bays and coves and estuaries and things like that. Then from the shoreline, from the low water mark to 12 nautical miles out, we have the territorial sea, and that's essentially considered part of the country. Canada has full jurisdiction within that territory, and its laws have full effect as if you were on land in Canada. And then the next area to note is the 200 nautical mile limit. And the area between that is called the exclusive economic zone. And coastal states like Canada have something called sovereign rights within that area, which means they can protect resources, living and non-living resources, and they can also harvest those resources. So that includes fish as well as oil and gas, minerals, etc. But countries also have a duty to protect the marine environment within that space. The difference between the territorial sea and the exclusive economic zone is that foreign states also have the ability to pass through. They have what's called freedom of navigation. So to some extent, a coastal state's jurisdiction is more limited, and that becomes very important when you're dealing with activities like shipping and what Canada can actually do to regulate those activities offshore. And then beyond the 200 nautical mile limit, or if the continental shelf is there beyond 350, you have the high seas, and that's not part of any country, and it's governed by international convention. I like this map because it gives you a sense of how all of those different layers play out on the BC coast. So out to the left, we have the exclusive economic zone. You can see it's quite big. Those thin bands, the blue is the territorial sea. The purple is, I didn't talk about it, but it's actually part of the exclusive economic zone. It's just like a buffer zone to the territorial sea. And then the blue hatching on the inside is what's considered BC's internal waters. And you can see it's a huge area. I'll talk about this a bit more when we come to provincial and federal jurisdiction, but that's unique within Canada that BC has such significant internal waters. And the last thing I'll just point out on this map is it's fairly up to date, and it shows the existing established protected areas and then a kind of gigantic, large proposed marine protected area in BC. And you can see, I think visually, that what's protected right now is not a huge area. So that's a big part of the work that we're doing right now. So getting into specific orders of government and the powers and authority that they have, the starting point is always Indigenous law. Indigenous nations have inherent jurisdiction within what's now called British Columbia and have been here since time immemorial, have their own governance structures, stewardship, and ways of managing those lands and waters, and that includes the ocean. And I think this is really helpful, this infographic I have on the right here, to talk about the distinction between Aboriginal law and Indigenous law. So Indigenous nations have inherent jurisdiction to govern their territories, and that includes the ocean. And when we talk about Indigenous law, we're referring to Indigenous people's own legal traditions. And those laws pre-exist colonization. And what inherent means is that it doesn't matter whether the Crown recognizes those laws. They are there, and they have, nations have the authority to enact their laws on their territories. But some aspects of Indigenous law, Indigenous rights and title are recognized within Canadian law through Section 35 of the Constitution, which recognizes Aboriginal rights and title. And so typically when we talk about Aboriginal law, we're referring to Canadian law that applies to Indigenous people. And there's a whole body of law under that category. And I just highlighted here the last point, which they've already mentioned, the UN Declaration on the Rights of Indigenous Peoples, which is slowly being incorporated into Canadian law, but also plays an aspirational role as to what countries should be doing, and allows nations to point to something, though it unfortunately doesn't have legal teeth within the Crown legal system until it's been implemented within Crown law. So this is a case study that my colleague Georgia Lloyd-Smith has worked on to give you a sense of some Indigenous legal initiatives that are being played out right now in those conflicts with Crown law, in this case federal law. So this is about the herring spawn and the herring fishery in Kitasoo-Hay-Hay territory, which is near Klemtu. I have a little map there that is small, but shows you, the small map shows you where this is on the BC coast. And I don't know how many people here have seen the herring spawn or been to it. I've been lucky enough to see it once. And it is amazing, as the picture shows. The water turns all milky. It supports an amazing amount of marine life. And that includes human animals who like to harvest herring roe. So we have on the bottom right is the commercial fishery that exists under Canadian law. But on the left is the traditional fishery as managed by the Kitasoo-Hay-Hay. And the traditional fishery, it can be called spawn on kelp or other, can use other types of plants, but typically would be inserting a cedar bough or kelp or something else within the water while the herring are spawning, so that the herring roe attach to the cedar bough, and then it can be pulled up and the roe can be harvested off of the cedar bough. So it doesn't affect any of the fish. It's quite sustainable. The commercial fishery is quite different. The fishermen catch the herring themselves, and then the herring have to be killed and cut open so that the roe can be extracted. So it's sometimes referred to as a kill fishery because of the fact that the adult fish have to die for the roe to be harvested in this way. And there's been concerns about the impacts of this fishery on herring stock over time. So the Kitasoo-Hay-Hay, we're concerned about the amount of commercial fish harvesting going on in their territory and wanted to limit it within certain areas. And so if you go back to the map, that red bay is Kitasoo Bay. And one of the ways that Kitasoo-Hay-Hay are exploring protecting the herring and preventing a commercial fishery from happening is through implementing a protected area under Indigenous law. And this type of area, it's referred to internationally and within Canada as Indigenous protected and conserved areas. And those are lands and waters where Indigenous nations play the primary role in establishing the protected areas and governing them under their laws and knowledge systems. They're Indigenous-led, there's a commitment to long-term conservation, and they elevate Indigenous rights and responsibilities. It's an area that we've been working in a lot and that there's been a lot of growth in, I should say, in the sense of nations bringing forward protected areas, either under their own laws or in kind of joint recognition under Crown law as well. And this quote is from a really wonderful report called We Rise Together by the Indigenous Circle of Experts that is excellent and talks about the history of protected areas in Canada, which was sometimes very difficult for Indigenous peoples. And there's an aspect of dispossession and Indigenous nations not being able to exercise their rights within protected areas. So this is a much more just and respects the inherent jurisdiction of nations within their territories. So we'll move from there to Crown law, and we'll talk about federal and provincial law together because they are quite connected, as you'll see. And people may know that the federal government plays a big role within the oceans, but you may not know that the provincial government in BC also has a significant role to play. So this infographic tries to give you a brief glimpse of the overlapping jurisdictions between the federal and provincial governments. You can see that in several key areas, both governments have a role to play. So I like the example of aquaculture because the federal government regulates the aquaculture industry within BC, but the province is responsible for land tenures that aquaculture happens on. So they play a role of managing them together. What's most important to take away from this graphic is that the province does not have jurisdiction over commercial fishing or navigation and shipping. And those are two very significant areas of activity within the ocean, and also areas that often, or activities that often we're trying to target when we implement marine protected areas. So that means that the federal government generally has to be involved in some capacity to establish a protected area in the water. I have an example in a minute of how sometimes they can work together. But I'm gonna go back to this map first because I wanna talk again about the internal waters within BC. So in the 80s, there was a court case called the Southern Strait of Georgia reference case in the BC Court of Appeal. And it was about whether it was the province or the federal government that had ownership, Crown ownership of the seabed between Vancouver Island and the mainland. And the outcome of that case was that, in fact, it was the province who owned the seabed. And the case came to be in the first place because both governments were interested in the minerals and oil and gas that were in the seabed. And the reason for that was that the incorporating documents referred to the Pacific Ocean west of the province, and the court decided that the west referred to the west coast of Vancouver Island rather than the west coast of the mainland. So it's quite interesting because in other provinces on the East Coast, for example, the jurisdiction of the province ends at the low water mark. But in BC, there's ownership of the seabed and then also the jurisdiction over the water column above that flows from that. We don't actually, the court didn't talk about the mainland, the area between the mainland and Haida Gwaii. So it's not been decided where ownership of that area lies, but the provincial government has asserted jurisdiction in a number of ways. There's some marine parks within those areas. So sometimes we refer to it as de facto under provincial jurisdiction. This is a picture of Port of Cove because it was the first marine park that the province of BC established. And it was an example of the province deciding that it was going to do something to protect the ocean and establishing this park that extends out over the water. What's interesting about Port of Cove is that there's a complementary federal shipping regulation that prohibits boat traffic within the area. So we'll talk about this a bit more later, but sometimes there's a lot of effective work can be done when both or as many governments as possible are brought to the table to layer their respective knowledge and jurisdiction to comprehensively protect the same marine space. And I wanted to talk about another example that's close to home, which you heard about, or the Nature Vancouver had a presentation on recently, the glass sponge reef closures in Howe Sound. Just to tell you that the legal tool that's used to close those areas is referred to as a fisheries closure, but it has special policy criteria attached to it, which require it to be established for at least 25 years and be primarily for the purpose of conservation. So the federal government refers to those areas as marine refuges. And that's a kind of close to home use of a marine protection tool. There's also in the Southern Strait of Georgia, potentially going to be a national marine conservation area established, and that's under the jurisdiction of Parks Canada. So even within the federal government, there's a number of different organizations that play a role in protecting marine spaces, of course, Fisheries and Oceans Canada being always at the table. But this is a pretty amazing success story for marine protection here. And that brings me to the last order of government, the littlest fish, local governments, which do play a role in protecting coastal and marine areas, really an outsized role in protecting coastal areas, given their size and their jurisdiction. So when we talk about local government jurisdiction, it's important to clarify that the Constitution of Canada divided jurisdiction at the time between federal and provincial governments, and local governments are really a sub-jurisdiction of the provincial government. They have delegated authority from the province through the Local Government Act and the Community Charter. And the way that authority was delegated was in part also through letters patent, which is this old looking document here, which were used to designate the boundaries of a municipality or region at the time that it was established. And sometimes those boundaries extend out into water. It really depends. The authority a local government has really depends on how it was defined in the letters patent. This is a map on the right of Parksville, and you can see that the municipal boundary extends quite far out into the water, and local governments have authority up to the extent of the boundary, but it's a bit more nuanced than that. The boundary line doesn't mean exactly that the local government has complete jurisdiction within that area. So another important boundary to consider when discussing shorelines and local government jurisdiction is the natural boundary, which is also the high watermark. So when the sea comes in during a storm, the highest extent that it goes is the high water mark in the natural boundary. And that's determined by surveyors actually walking down the beach and deciding where that line is. And so then between the high water mark, the natural boundary, and the low water mark is what's referred to as the foreshore often. And within that area, the provincial government has kind of full jurisdiction, subject also to federal and Indigenous jurisdiction. But as between the provincial and local governments, it's really the provincial crown that it's considered provincial crown land, essentially. And so local governments usually have a fairly good understanding of that, but some conflict can and does often come up with private property owners who may not have as good of an understanding about where their ownership and crown land begins. And there's a really interesting case recently from Mudge Island, near Gabriola Island, decided after the guide came out. So it's going to be our first update to our new book. But Mudge Island is governed by the Gabriola Island Local Trust Committee, part of the island's trust. And what happened there was a resident who constructed this is a picture of it, this concrete seawall to try to protect their property from erosion. And after they constructed it, the island's trust, the Gabriola Island Local Trust Committee passed a bylaw, a zoning bylaw that required all human-made structures to be set back at least 30 meters from the shore. And the reason for that was that natural shorelines are incredibly important habitat and they need to be protected. The landowner asserted a common law right, and I wrote it down because it was so great, to protect one's property from erosion caused by inroads of the sea. Common law rights are historic rights that come usually from England that were decided, they can be hundreds of years old. And so the landowner asserted this right and said the zoning bylaw shouldn't apply to me. I don't have to take my concrete seawall down. And the BC Court of Appeal in January decided that those common law rights are subject to local government regulations, which include zoning. And those zoning regulations are able to include seawalls, which is great news for local governments that are trying to restore shoreline habitat. And great news for the island's trust, which I think has over 1,000 kilometers of shoreline under its jurisdiction. So the last topic I want to touch on tonight is, I think it's clear that there's a lot of different layers of jurisdiction that can apply to the same marine space, and that intergovernmental cooperation is incredibly important to get anywhere. And I want to talk about initiative on the north coast of BC that's really exciting, and an example of intergovernmental collaboration that hasn't really been seen anywhere else so far. It's quite groundbreaking, and it's Canada's first marine protected area network. So it will be in this area that's you can see in dark blue between northern Vancouver Island up to the border with Alaska. And it's been a tripartite process between the federal government, provincial government, and Indigenous governments whose territory it's in. And the idea behind a marine protected area network, I'm not sure if any scientists would have spoken about it, but is to designate not just protected areas in isolation, but to consider where to put the protected areas to make them as connected as possible and as representative as possible of different habitat that species need at different stages in their life. And the protected area planning process has been undertaken by a collaborative team of the provincial, federal, and Indigenous governments, and eventually will be designated within the area. And I mean, to see all governments work at the table, working together and agreeing to a plan means that that plan will last a really long time. So right now, we're in the stage of, we have a draft that will be released to the public next September as the current timeline, and then it should be designated by 2025 and 2030. There's a few phases, but West Coast and a lot of other NGOs have been working on this, figuring out, like, providing advice on the best ways, the best legal tools to use, the best ways to implement the network, the best areas to protect. And we're really excited to see it go forward. And I think I'll just mention too that now that this process has been so successful on the North Coast, Fisheries and Oceans Canada is starting to look at ways to plan marine use on the South Coast as well, which is really important, as we know, because there's so much traffic and use and just activity in the ocean in the southern part of British Columbia too. So I just wanted to say thank you. I just have my name here because I'm the only one here tonight, but this book was written by a wonderful team of lawyers and reviewed by an amazing team of reviewers, and could not have happened without the support of our funders, the Sitka Foundation and the Gordon and Betty Moore Foundation. And I want to show you, because I just picked them up yesterday, that we have print copies available now. So if any of this is something you'd like to learn more about, you can also find it on our website. There's a lot more there if you have any questions. And we're also always happy to hear from people who are pursuing some type of protection and need legal support. So thank you very much for your time, and I will stop sharing